Good evening, respected folks and my dear friends. Hope all of you had a rainy and cozy evening. First of all, a very big thanks to each and everyone present here for attending our session. On behalf of St. Peter's College, Kolenchery, in association with Department of Biotechnology, together with IEDC, IIC, IPCell, and IQAC, I happily welcome all to this section. Let's start our today's session with a silent prayer. Okay. A man with great vision and mission is an icon of hard work. So, here I wholeheartedly invite Dr. Lowwellman P, who is our chief guest, and he's going to talk about IPR and IP management for startup. He's working as an assistant professor at Government Law College, Kozhikode. He has crossed all boundaries of excellence with great spirit towards his profession. So, doubtlessly, we can say he's the right person for this talk on IPR. I wholeheartedly welcome you, sir. And then, I warmly and respectfully welcome our dearest principal, Dr. Shaju Varghese, who has always been the pillar and the backbone of our college. Thank you so much, sir, for encouraging us to do this session. With respect and delight, I welcome you, sir.
Okay, thank you.
I am so profoundly delighted to welcome the person who is behind all of this, Dr. Sona Esde, head of the Department of Biotechnology. It is not what is poured into the student, but what is planted. That counts. Thank you so much, Sona ma'am, for always opening doors of wisdom towards us. Thank you for guiding us. I call upon Sona miss for welcome speech.
Okay. Good evening to one and all attending this session on IPR and IP management for startup. So over the years, the government has made an honest effort to spread awareness regarding the importance of IPR among the startups by highlighting its necessity and also offering various incentives for startups to protect the IPR rights. However, despite the best efforts, there exists a massive void amongst the entrepreneurs in relation to understanding the importance of IPR prior to or during the operation of a startup. Henceforth, we have organized this talk so that the budding entrepreneurs of our institution get an insight into the IPR in the context of the startup ecosystem. Let me now do the honor of welcoming all the participants. At the onset, I welcome our principal, Dr. Shaju Varghese, who is our main pillar of support, and he has extended all his support for the conduct of this program. Today, we have with us Dr. Lowwellman, Assistant Professor, Government Law College, Kozhikode, as a resource person. He has completed his Master's in Law from School of Legal Studies, Cochin University, with specialization in IPR. And he had his PhD research work also in the topic IPR from National Law School, Bangalore. Dr. Lowwellman has been a resource person for various IPR and related programs within and outside Kerala. We are certainly grateful to him for readily accepting our invitation. On behalf of our college, I cordially welcome you, sir, to this session. I would also like to welcome Dr. Renu Susan Samuel, Assistant Nodal Officer and President, IIC SPC, faculties in charge of IPCell, Dr. Gina Varghese, IQAC Coordinator of the college, and all other faculties of IEDC, IICs, and other faculties. Finally, with utmost pleasure, I also welcome our dear students who have spared their time, valuable time for attending this session. So before I conclude, a special word of appreciation to all the students and faculties of Biotechnology Department for their wholehearted support and involvement. Thank you.
And now I invite our dearest principal, Dr. Shaju Varghese sir, for presidential address.
കേൾക്കാം എന്ന് വിചാരിക്കുന്നു.
കേൾക്കാം.
ഓക്കെ. എല്ലാവർക്കും നമസ്കാരം. പ്രത്യേകിച്ച് ഇന്നത്തെ ഈ ക്ലാസ് എടുക്കുവാനായി എത്തിയിരിക്കുന്ന പ്രിയമുള്ള ലോവെൽമാൻ എന്ന പേര് ഞാൻ ഇതുവരെയും ജീവിതത്തിൽ ഇങ്ങനെ ഒരു പേര് കേട്ടിട്ടില്ല. ഏതായാലും ആ പേരിട്ട മാതാപിതാക്കളെ ഞാൻ പ്രത്യേകം അഭിനന്ദിക്കുന്നു. കാരണം വളരെ ചെറുപ്പത്തിൽ തന്നെ ഈ പേരിലൂടെ ഒരു ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ് അവർ കുട്ടിയുടെ മനസ്സിൽ ഉണ്ടാക്കിയെടുക്കുവാനായിട്ട് അവർ ശ്രമിച്ചു. അതുകൊണ്ട് തന്നെ അദ്ദേഹം നിയമം പഠിച്ചു. അതുകൊണ്ട് തന്നെ അദ്ദേഹം നിയമത്തിൽ മുന്നോട്ട് പോയി. അതുകൊണ്ട് തന്നെ ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടിയുമായി ബന്ധപ്പെട്ട കാര്യങ്ങളിലെ റിസർച്ചുകൾ, ഗവേഷണങ്ങൾ നടത്തി. ഇപ്പോൾ ആ പേരുമായി ബന്ധപ്പെട്ട് ഇത്രയും ചേർന്ന ഒരു പേര് ഇനി അദ്ദേഹത്തിന് യോജിക്കുകയില്ല. ഏതായാലും ഈ പേരിട്ട മാതാപിതാക്കളെ നമസ്കരിക്കുന്നു ഞാൻ. നമ്മൾക്ക് ഇങ്ങനെ ഒരു ക്ലാസ്, ഒരു സെഷൻ എടുക്കുവാനായിട്ട് അദ്ദേഹം വന്നതിൽ വളരെ സന്തോഷം. സത്യത്തിൽ സാറ് നേരിട്ട് ഈ കോളേജിൽ വരികയും ഈ വിദ്യാർത്ഥികൾക്ക് ഒരു ക്ലാസ് എടുക്കുമായിരുന്നു വേണ്ടിയിരുന്നത്. ഇനി അതിനൊരവസരമുണ്ട് എന്ന് ഞാൻ വിശ്വസിക്കുന്നു. കോളേജിന്റെ IIC, IEDC, അതേപോലെ IP സെല്ലുകൾ 3 പേരും പിന്നെ IQACയും കൂടെ ചേർന്നാണ് പ്രോഗ്രാം. ഇപ്പോൾ പുതിയ കാലം എന്ന് പറയുന്നത് പുതിയ പുതിയ സംരംഭങ്ങൾക്ക് വിദ്യാർത്ഥികളെ പ്രചോദിപ്പിക്കുക, അതിലേക്ക് വഴി നടത്തുക എന്നുള്ളതാണ്. എല്ലാം ഒരാശയത്തിൽ നിന്നാണ് ഉണ്ടാകുന്നത്. ആ ആശയങ്ങൾ എങ്ങനെ നമ്മുടെ ബൗദ്ധിക സ്വത്തവകാശവുമായി ബന്ധപ്പെട്ട് നിൽക്കുന്നു എന്നതായിരിക്കും ഈ ക്ലാസിന്റെ വിഷയം. വിദ്യാർത്ഥികൾക്ക് ഏറെ പ്രയോജനം, അധ്യാപകർക്കും അത് പ്രയോജനപ്രദമായിരിക്കും, സംശയമൊന്നുമില്ല. ഏതായാലും ഇതിനെല്ലാ ഭാവുകങ്ങളും നേർന്നുകൊണ്ട് ലോവൽ മാൻ എന്ന് പറയുന്ന അധ്യാപകന് എല്ലാവിധമായ ആശംസകളും നേർന്നുകൊണ്ട് ഞാൻ എൻ്റെ വാക്കുകൾ നിർത്തുന്നു. നന്ദി, നമസ്കാരം.
Thank you so much.
Last but not the least, I welcome all my friends and faculties who has got all ears for this session. I am pretty much sure that this session will be really helpful for us. Thank you for joining. I am welcoming you all again. Now, we are moving on to our session. My genial welcome to our special guest, Dr. Lowwellman P, to pour his knowledge and grasp on intellectual property rights and intellectual property management. Welcome, sir.
Thank you, Anakha. Thank you, Anakha, for an agile, being an agile MC, Master of Ceremony. Respected Principal Dr. Shaju sir, Dr. Sona Madam, with whom I had a discussion, or rather, a discussion for having this class or seminar, whatever we call it as, and dear students. Madam Sona, the students are from the Department of Biotechnology, right?
No, it's almost the whole college. Different department students are here. Some of them are members of the IEDC, IIC, some are from IP cell. So like most of them are having exams. That's why we couldn't, many of them couldn't join actually. They're having university exams for, I think 2 years, almost 3 years, they're having exams university. So majority of them couldn't join. So it is not confined to biotechnology department alone.
Okay, ma'am. Thank you for that. So I must thank the principal for the nicest of words, and also Madam Sona for inviting me. So it's my privilege to be with people of this esteemed institution. You know, though I belong to Malabar, I worked in Cochin. I studied in Cochin. I worked in Alua. So in the during this period, I had the opportunity to visit Kolenchery and places like that. So Principal Sir has already talked about my name, though this presentation has nothing to do with my name as such. So I've titled the presentation as Contours of Intellectual Property Rights. And I work as an assistant professor in Government Law College, Kozhikode. My name is on the screen. And my presentation is going to be a combination of my talking and also the slides, which you can see. Ma'am Sona, the slides are visible, right? Ma'am, the slide is visible. Thank you so much. So
It's visible, sir. It's visible.
yeah. So I think I've got a new picture. I think the new picture I'm trying to post on the screen is visible to everyone. That picture is so contextual. I think that will put the things in perspective. Intellectual property rights. Intellectual property is a special kind of property which has something to do with intellect of a person. And this connection of this kind of property with intellect makes that special. And that's the reason why it's called as intellectual property rights. So as you can see on the screen, as per the new picture, the innovation starts with new ideas arising in the mind of a person. And when you are able to translate those ideas into useful products, you have intellectual property rights with regard to that. And if we think further on the intellectual property system, it could be something like this. I've got a Tumblr over here, which I think is visible to all the esteemed participants. Hi from my side to all the students. I expect a reply, a response, at least in the chat box. Hi to everyone. So
Hi,
in this
sir.
Tumblr, thank you so much. Thank you so much for the response. So the chat box should hi Mariam Rod, hi everyone, Rohit Chakib, hello, hi. Thank you for responding. Suhasini, Yasmin, Suhani, thank you. Saranya, hi Saranya. Angela Sarah Ben, good name. Shahin, Arya Sudesh. It's good to know. It's good to say hi to you. Hi. A very good evening to everyone. So intellectual, hi to Anna also. So Ravi, Ramesh, yeah, that's really encouraging to me. Ashwarya. In fact, I expect some sort of encouragement from the side of the participants and the students. We, the teachers, also require some sort of encouragement, and you are giving that along. Thank you for that. Yeah. So coming back to our intellectual property, we will have this journey together. Thank you for being with in the same boat. Intellectual property system has its basic material from the area of science and art. I'm sure that you have heard about patents, though you may not know much about it. In the case of patent, which is one of the major intellectual property rights, the subject matter, the basic matter that gets intellectual property right is an invention. So when we talk about invention, I think it goes without saying that invention goes with, or invention is connected with science and technology. So the departments of science and technology in this college, in this esteemed college headed by Dr. Shaju, and all other departments will have something to do with intellectual property rights. It's not that it's not only science and science departments that will have some stake here. Even arts department will have something to contribute. You must have heard about copyright and other intellectual property rights. I think it is one of the most popular intellectual property right. And the most popular intellectual property right, copyright, has its materials coming from arts and the areas of literature and whatever you call it is. If you write a book, you have an intellectual property copyright there. So whatever innovative you have, perhaps a vaccine for corona, or a new book which you have written, or anything else, a machine you find out, or an automobile which has got 100 kilometer per liter, which will be very much useful, which will definitely have a market, because the um, the price for petrol and diesel is skyrocketing. So all these will come from different departments. And even if you have a new kind of plant coming from biotechnology department, that also may have an intellectual property right. So we have things coming from all the departments. All the departments will be stakeholders in this. And what you do is, if it is something very useful, like a new kind of plant which is very much useful, or a new book which is very much useful, or an innovative idea which is translated into mission, or a medicine, then definitely there is a possibility of commercializing it. So economics department also has something to say here, or something to listen to, because what you're dealing with is something very useful to the society, very useful to very many people. And the people who have spent a lot of time on this will definitely be entitled for some sort of right over that. So you're commercializing that. So the basic material of intellectual property comes from science and art. And when you talk of commercialization of it, you are talking about commerce and economics and things like that. And to go to the title of the presentation, or title of the session is intellectual property for startups. So startups will be of will benefit enormously if they have an intellectual property right. So when you are dealing with something very useful, and when you have a great market potential for that, then definitely there ought to be disputes. When there is actual disputes, or there is a potential for disputes, then you have the third item coming in. It is also must. The third item or third material, third thing which is included in intellectual property is legal rules. Then we come in. When I say we, the law people. So you have science and art in this, you have economics in this, commerce in this, you have legal rules in this. So it is definitely an interdisciplinary subject which everyone should be concerned about. And that might be the reason why, as Dr. Sona was putting across, there is a mandate from the side of UGC and the other higher education control departments or authorities that there should be intellectual property sessions conducted in every college. And to my knowledge, it's going to be a subject even for engineering and things like that. So that's a context in which we would speak more about intellectual property rights. And I think I'm making sense. Am I? The students there? I hope I'm making sense. Am I? NS would be appropriate, or no also could be appropriate, because I can go for that again. Yeah, Rohit, thank you. Rohit was the second person to respond there. Now he is the first to respond. Now, if you consider this as a journey, and in this journey, what are the main places we are going to visit? If you consider that, if you think this as a journey, then it will be more interesting for us. The items or the places we are going to visit are patent. The first item of intellectual property is patent. Second one could be trademark. Third one could be industrial designs. Then you have copyright, which I made a mention of already, which you might already know. Semiconductor chip protection or IC chip protection is another one, just something to do with electronics. I hope it is understandable. And you have plant variety, much important for technology department. Then you have GIS, that is geographical indication, that is expansion of that. And obviously, not the list, the 8th item is trade secret. The point I'm trying to make here is this: when we say intellectual property, when you are not speaking about just one item of property, you're speaking about as many as 8 items of properties. 8 items will constitute this terminology, this phrase, intellectual property. And our discussion today, maybe for the next 1 hour or so, is going to be on these 8 items: patent, trademark, industrial designs, copyright, semiconductor chip, plant variety, GIs, and trade secret. So that's the agenda for the day. Let's move. So as the first item, you have a patent here. Do you identify this person? And my questions, the respected members of faculty, please pardon me. The question will be to the students. Do you identify this person? Do you identify? So Jacob or anybody else? Aishwarya, those were the people who responded to that. Any idea? You have a clue in that itself, the picture itself. Isn't it visible? Is that visible?
Sir, Thomas Alva Edison.
Yeah. Thank you. Thank you, Aishwarya, for responding to that. How do you understand this? How good was the clue?
Bulbing his.
Kaina bulb undallo alle? Okay, definitely. That's good. And that's the power of an invention. Aishwarya knows that, and I would know this, and every one of us would know this, because this was a game changer. ചരിത്രമായി മാറിയ ഒരു കണ്ടുപിടുത്തം. This has become history, and it has changed history. The way you live, your facilities have changed, or the way you see the night has changed. So that's something which is useful to the society, and it goes without saying that Edison has spent a lot of time on this. He has really become intellectual labor to find this out, and to bring this out in the market. You definitely have to spend a lot of investment with this. So this intellectual labor and investment is important. It comes from a particular company or a particular person, and to encourage that person to come out with the things similar to this, you grant intellectual property right, and that is the kind of system we have. So you have another picture on the screen. I hope this is familiar. This is you can see this. It's available on the screen, and I would like you to see this from left to right. You have an office chair of the year 528 BC, 522 BC in the picture on the left turn end. That is just a piece of rock on which a person of that time, whether that time had any no office chair at all or offices at all, is a different question. This is for the purpose of understanding. And this is an office chair of BC 522. And you get to see innovation in that. In 400 AD, can you look at the second picture from the left-hand side? You have something like a stool there with 3 legs. So that is an innovation. And then you have 1400 AD, wherein you have 4 legs instead of 3, and you have a rest. You can rest. You have a back for that. Then 1900 AD, you have a cushion, you have armrest, and you have that back also. So this is better, though it has got only 3 legs. It is definitely better than the other. Then again, you get to see the innovation in the 4th, 5th, 6th, etc. When it reaches the last one, you have a chair where you can move without getting up. which makes you more and more lazy. And that's how the life is. And you have armrest, you have better cushions, you can stretchable back, you have all those. So this is how the innovation happens. And with these pictures, I have two points to make. The points I would like to make here are, and please listen, kindly listen. The points are this. The first example I gave for the invention or patent was the bulb of Edison. So when you get to see that there is a problem, the students here and perhaps the faculties also will have a disconnect in the sense, and they will have a thinking that this is something something which should change the world. Such it should be something historic. This is something which I and you can think about. That may be one of the thinkings which I wanted to, trash out. And another one is this. It could be as simple as this. That's the first point. And another one is this. The invention need not be something completely new, fully new. If you can see in this, the incremental innovation. Second is an innovation on the first one, incremental innovation, first one. And third is an incremental innovation on the second. And fourth one is an innovation on the third. Chair as such is not new. So the new features of the chair is patentable. I hope it's being made clear. And if you move with this as the foundation, if you ask the question what the patents could look like, patent has got two incarnations, if I can use the word incarnation. The first one is a product patent, and another one is a process patent. Second one is a process patent. So the product patent could be anything like a medicine, or it could be something like an automobile, or it could be any other product which comes to the market, or which people like me might invent. And our usual understanding of an invention ends there. But patent law amends that. Patent law requires us to amend it. In the sense, you may have to change your idea about invention. Here, when it comes to patent and the system of patent, intellectual property, even a process, I stress that, even a process could be considered as an invention. A technologically innovative process. Just think of the same examples like medicines or automobiles or anything of that sort. And now there is a manufacturing process, manufacturing method of manufacturing, with maybe very cumbersome. It's a lengthy process, a delayed process, and perhaps it's very expensive also. And tomorrow or in the future, someone else is coming out with another process, a technologically innovative process, which is less expensive and less, it's not that very cumbersome, it's easy, and there is no much delay in that. So this is a process, though the product is the same, wherein you have a technologically innovative process. If there is a technologically innovative process, that is an invention for the purpose of patent system. So these are the two kinds of patents available for under the patent system. So moving on with this, what are the qualifications for a patentable invention? Let's have clarity about it, because I'm told, I'm given to understand that there are people who are budding commercialists. No, you're at the portals of commercialization, and you're going to have startups. So it's necessary for you to have the understanding of qualifications of a patentable invention. So it goes like this: any product or process which is, the first condition is that which is new. So it goes without saying an invention should be new. It's only inventions only new things which we call as inventions, new or novelty, and that should be new in the world, in the sense of the first time it's being used, or it's seen, or it's used, or it's known, or it's published in the world. And novelty or newness, if I can say within the inverted comma, novelty by itself is not sufficient. There may be something like a bucket torch. Have anyone come across a bucket torch? I hope no. The answer could be no. Bucket torch is nothing but a torch attached to the bucket. Torch attached to the bucket. But bucket torch, if it is there, it is not patentable, though it is new. As it is not known to anyone, it will be new, but a novelty of that sort is not sufficient. You need to have inventive step or technological innovation involved. So a novelty based on technological innovation is the requirement of patent law. Now I invite your attention. I invite the attention of the esteemed participants and the students there to the screen. You have 4 bulbs, if I can say so, there. The first one where you have something on a bulb, which is a very old one, which you and I might not have seen. But I'm sure that you must have seen the second one and used it also. So there is a technological innovation from you move from the first one to the second. Though I may not be competent and may not be possible here to explain that out, but it is definitely perceivable that there is a technological innovation. There is an inventive step when you move from the first to the second. And if you consider the third one in relation to the second one, in comparison to the second, in contradistinction to the second one, what you have is a technological innovation, a bulb to CFL. And then you have something from third to the fourth, and then you have what do you call light emitting diode, LED we call it as. So there is novelty and there is inventive step also, or rather novelty based on inventive step. Now the third requirement is industrial utility. Industrial utility is a requirement from the side of the society or the users. Novelty and technological innovation by itself will not constitute a patentable invention unless the use to which it can be put is positive. If the machine with which you come out or you claim patent for has a negative use, for example, something for robbery, like a machine which is new and which involves the inventive step, and it can be used. It's very useful for breaking the locks open. Definitely, it is. It's complying with the first and the second requirement, but it will have a hurdle in the third, and it will stumble there. Okay, so these are the 3 requirements. Then, if you are moving on, who can apply for a patent? The person who can apply for patent could be true and first inventor, or it could be an assignee. Assignee is a person who takes or gets that transfer, gets invention transfer from the original person, or the legal representative. Legal representative, as far as company is concerned, is a company which takes over the present company, or legal representative could be a legal relative who can represent or who takes property from the earlier person. So these are the 3 category of people who can apply for a patent. And please note, you don't have a patent right on an invention, even though invention is complies with all the requirement. You don't have a right over that unless you go for a registration. In other words, registration is compulsory, or registration is a precondition to get a patent. If you invent and patent, you prosper. If you invent and publish without patent, you perish. That's how it happens. Moving further, you have certain rights available in the case of patent. When you get a patent, you get some rights. These are all commercial rights, business rights, with respect to science and technology subject matter. You have the right to manufacture a patented product. You will have the right. Only you will have the right. Nobody else will have the right. You will have the right to use it. Only you will have the right. Nobody else will have the right. And if somebody does that, you can stop that. Similar is the case with selling, importing, etc. So put it in different sense, in commercial sense. You will have the exclusive right to commercialize it. So you have the exclusive opportunity to recoup cost and make profit. That's how patent makes sense to a person who is about to launch a startup. If you have a patent, it's easier for you to go for a startup. By the way, may I ask a question? What's your opinion about monopoly? Is it good or bad? Monopoly? Is monopoly something good? If I can ask the same, I've got some names over here, right? Anaga, Elsa, yeah, baby. Anaga, Sarah, when you have different, yeah. And anybody who can respond to this, it's good. It's good. Rohit, what is it? You said good or bad? I couldn't. It's bad. Rohit says, is there anyone who thinks that it's good? Is there anyone who thinks that it's good? Monopoly. When you speak from a public point of view, we are all given to understand, we are all socialists in that sense. We are all given to understand, our opinion will be that monopoly is bad. But the fact is this, everyone, including me, you and me, everyone, are selfish, or everyone is selfish. It's actually a reward for an innovation. Yeah, that makes sense. That's what I'm about to say. So you're just a step forward. That's good. Chaku, that's good. So my point is this. Thank you for putting that across. I'm happy about it. So here, the thing is like this, but all people are selfish, I would say, to some extent. Maybe not with money, maybe with the degrees, maybe with promotions, maybe with certain career advancement points, perhaps with many things, with reputation, with money, with property, etc., etc. So that basic instinct of people like you and me, perhaps anyway, I'm selfish. I'm saying this. Yeah, in order to encourage those kinds of people, because it is notable that all innovations have not come from government laboratories. Most of them have come from private people and also from private companies. And government may not have enough capital, if I can use the word as it is, capital to invest for innovation. So you have a mechanism in law or in commerce or in science, wherein you say that if you invest a sizable amount, and if you invest a lot of effort on that, if you really become an intellectual laborer, if you have both of these, you can come out with an innovative product. You can have an idea, then you can translate that into a product or process. And if it is useful to the society, if you see the requirements there, it should be useful to the society. If it is negative use, then you don't have a patent. So it should be new, it should have inventive step, and it should be useful to the society. So you have something which is useful to the society, then you have a monopoly. As Chaku was putting that across, this is a kind of reward, something in return from the society. Society gets something positive, very positive, because of the effort of a company or a person. So to encourage that more, to incentivize that person or a company, you have something like a monopoly. This is nothing but monopoly, which is law protected. That's the beauty of it, whether you like it or not. But there is a justification for it. The justification is that it is to encourage people like you and me to go for this. So I'm sorry, Mr. Jacob. Jacob will say that we may not be with you, at least in this instinct, but on a general plane we are with you. Monopoly is not good. Monopoly is bad, and in a way, even in patent law, it is like that. The law of patent is for a limited period. It is not of a it's not of a permanent nature. It's not perpetual or permanent. It's for a limited duration of time, as you can see on the screen. The duration of patent right. Please note, we are with both Ambili Chaco and Mr. Jacob. Monopoly is good and monopoly is bad also. It is yes and no at the same time. So duration of patent right is for 20 years only. So this is considered to be a reasonable period to reward. Reasonable period to reward a person, incentivize a person, encourage a person to come out with an invention. He gets right. He is he's a monopolist. He gets a monopoly right. He's the king and Raja there and Sultan there for 20 years. That's good enough a time. So you have the competitive edge at the end of 20 years. And after that, it goes to the public domain. Anyone like you and me can lay our hands on that. And the law that deals with patent right in India is on the screen. It is Patent Act 1970. The law was passed in 1970 and it was enforced. It has been enforced from 1972. So this is a brief about intellectual patent right. With this, we'll move on to the next. Can anybody recollect which is the second one? Which is the second one? Anybody from the part of students? Hi, you're there. The second one in the items of intellectual property rights. Anybody? Anybody? Suhani, Asmin, you there, or shall I move on?
Trademark.
Trademark. Thank you. Thank you that you answered. Do you identify this, Miss Suhani? Do you identify this? What do you have on screen?
Apple.
What is this apple? What does it represent? I'm sorry to continue with the questions because I got some answers. What is this? What will it remind you? Yeah, it would remind iPhone and things like that, right? So let's make a list of things you are reminded of when you think of a trademark, a brand. You may be reminded of the product, as Suhani was reminded of iPhone by seeing this, though nowhere it is written that it's iPhone and Apple. So you are reminded of a product or service. You are reminded of the source, the company from which it comes. You are reminded of you get the capacity. This is a means to distinguish between your product, the company's product, from the product of another. When you say Apple, when you identify Apple, you also distinguish that from Acer, distinguish that from Dell. Same is the case with Suzuki. When you say Maruti Suzuki, you mean that it's Maruti Suzuki. It comes from Maruti Suzuki company, Japanese company, which has got a strong hand in India. So it also means it is not Hyundai. It's not Honda. It means that as well, because companies are here to sell products, and it's to sell their products, and they want something which which can represent them, which can uniquely represent them in the market. And that function of identifying the company and the products in the market, which is very important as far as company is concerned, is discharged. That function is discharged by the thing called trademark. So you are also reminded of quality. I can give some examples like I'll utter two words. You have nano here, you have Benz here. So Benz definitely will remind you of a very high quality product, and nano will go to a very different segment. So it's about quality as well. And this is a wonderful advertising tool. This is really multinational. Coca-Cola is the word, I think, which is known in all the 193 countries. So if you have the word Coca-Cola, and if it has got the capacity to remind the customer all this, then it is a wonderful advertising tool. So all these put together, we'll call it as a goodwill. I think it is. It's the idea is communicated to the participants. And so you have a startup in mind. So what can be used as a mark? It could be something like a word or a letter, as you can see on the screen. It could be a word like Tata, or it could be a letter like T. It could be a logo like a Nike logo you have on screen, or it could be something like a numeral, or it could be a drawing or a picture like Kentucky Fried Chicken, or it could be a label which is stitched to the product or attached to the product otherwise. Or this could be trade. And this is something which you might understand from the very common sense you can understand, but we need to extend that. And trademark also includes things like this. What is this? If you look at this, if you go for a close look at this, you get to see that the words Coca-Cola is written over there. I'm not on the word Coca-Cola, but I'm on the shape of the bottle. Without being able to read Coca-Cola there, if by perceiving this by eyes or by touch or any other way, by perceiving the shape of this bottle, if a person can identify, a customer can identify that this is Coca-Cola, that means that shape is in a position to represent the company and its product and the goodwill. If the shape has got the capacity to do that, the shape itself, apart from the words Coca-Cola and the color combinations there, the shape itself can be what you can call as a brand, a trademark. So there could be very many examples. Ujala, I think Ujala could be a good example for that. Do you have any other example from India? An Indian example? An Indian example for this, a shape trademark. Is there any sound, a unique sound? If you come across that, if you perceive it, you are reminded of a company. How about Airtel company and its trademark? The music I'm speaking about. Once you get to listen to that audio clip, you are reminded of Airtel. So that that music clip, audio clip, has got the capacity to represent the company and its goodwill. Then it's a trademark. Then it could be color, it could be smell. Just think of our household thing like Dettol. Even without nobody telling you, you identify the smell, right? Taste, packaging, moving images, all these, apart from the traditional ordinary trademark, you have all these items are also trademarks. So do you identify this? Do you identify this? Anyone? Saranya S, do you identify this?
Yes, sir.
Could you just tell us what is it?
It's a Marcus SBI.
SBI. Where is it written? Is that written over there?
No.
And then how do you identify?
Just
Because you as a customer in the market is able to identify this. This is the best test. This is the best illustration that this particular logo has become a trademark, and it has got the capacity to represent a bank and its services. Perhaps in 1955 or so, that is the year in which State Bank of India law came into existence, and perhaps I suppose State Bank of India was established. And at that point, this was just a blue-colored keyhole. That was the only meaning it had, and I did not have any other meaning apart from this. But over a period of time, because of the advertisements, because of the because of the sponsorship, perhaps because of the mouth publicity, because of the services it's provided, because of all this, it is being transformed as a brand. Apart from the blue-colored keyhole, today when I ask Sharanya, she says it's SBI. So this could be the best illustration, I think, from the part of the audience itself to show that it has become a trademark. It has got the capacity to identify the company and its service there. I think the point is clear, Sharanya. Now, going further with this, how do you get legal protection for this? You can either go for registration, you get protection with registration. You need to register under trademark law as required there, as per the procedure under trademark law. There is a trademark office also. And please note, unlike patent, here there is a possibility of unregistered patent office, unregistered trademark also. You have something known as passing off. And that law of passing off, a person of unregistered trademark will also be able to have right, provided if you can show in the market that you have a presence, you have people identifying you as trademark holder. So if you have created a goodwill in the market, then you have a legal protection even without registration. On that point, it's much different from patent. And when you get a right over trademark, you get the right in relation to a particular class. You get the right in relation to a class, like class 2. What could be an example in class 2? Paints, varnishes. So there is a classification of goods and services under trademark law. So when you register a trademark, you will have to register in a particular class, which means that you will be getting your right in relation to those products in that area of business. So Asian Paints would be one of the examples under class 2. Or similarly, you have class 12, where you have vehicles, apparatus for locomotion by air, land, and water. So you register in different classes. And duration of protection is unlimited. Again, there is a distinction from patent. Patent is for 20 years. It's a kind of monopoly. This monopoly is for an unlimited duration. It goes on and on. So it's perpetual. And going further with this, what are the rights available to a trademark owner? If you ask that question, the answer is on the screen. You get the right, as a trademark owner, you get the right to prevent. You have the right to use and you have the right to prevent use of identical or deceptively similar trademark. Identical or deceptively similar trademark on similar goods and services. So if you go for a meticulous reading of that, so there are two conditions required and for exercising your right. First one is that somebody else is using a similar or identical, deceptively similar or identical trademark, and that too on similar goods and services. And now I invite your attention to the screen. You have got an example on the screen. Are the two products you have on the screen are the same? Home lights and home lights. People like you and me, which are we're all in higher education, arena. So we are considered to be a little sophisticated, but people like us, even people like us, may get confused. So if there is a possibility of getting confused, the customer is being confused, then what happens is the amount or the money that should have gone to the first company is going to the second company. So second company is making use of the goodwill of the first company, which is not allowed under intellectual property law. So this could be one of the examples of deceptive similarity and use on a similar goods. This could be a trademark violation. I think point is clear. But please note, it means are these violation? is Malabar cement a violation of Malabar gold and diamond, or is Malabar gold and diamond a violation of Malabar cement? What do you think? What do you think? Sneha ER, are you there? What do you think? No, I just called out a name. If you're there. I think nobody is there. But please do understand. Anybody? Anu Saju, Aisha, Devika, Krishna. Anyone? Please note, these are violation. It can coexist as these are in different areas of business. This will fall into different classes under trademark system. Because Malabar, the first one is a cement, which is much different from business like jewelry. So these, you can guess that will belong to different classes. So you don't have different classes, and so it will not be a violation. So with that, we complete the discussion on trademark. We'll move to the third one, that is industrial design. So just think for a moment. You are in a crockery shop, wherein you have different crockery items. You are here to buy something like a glass to drink your water, drink your liquid, whatever it is, tea, coffee, or it could be lime juice or anything else. So it's all will cost. Each one of it will have the same cost. It is 200 rupees per piece, and it will have the capacity to contain 100 ml of liquid, whatever it is. If I ask you which one are you going to select, I'm sure that if you look at this, you'll have different answers. Though the function is the same, though the price is the same, you will have different options because it has got different designs. So what you look at is shape, configuration, color, lines, etc. So it happens in a jewelry. It can happen in respect of sarees. You have designer sarees. It can happen in the case of toys, mobile phones, even automobiles. So it's very important in a market situation when you can't differentiate your product on the basis of price and functions. There is a possibility that you can present it on a plate. Like if you're giving it in a presentable manner, in a way in which it can attract the eye of the customer, then you have you can say that you have an intellectual property in the form of industrial designs. Here, what you think about is the design of the thing, design which is attached to, which make the product attractable, enticing. So if it entices a few people in Kolenchery or the nearby places, I'm sure that it will attract at least 1 lakh more people in the whole of Kerala. And if you think India as a market, maybe 10 crore or 1 crore or 10 crore, that is great business. And behind all this, there is a lot of investment, or there will be a lot of, it comes in the form of an idea in the mind of a person, and that is being translated into what you call a design. So what you can say is these are the requirements of a design. To have a design right protection, you should have a new and original design. You should have right to prevent unauthorized use, which is similar to that of trademark. Registration is compulsory. There it is similar to patent. And duration of protection is in comparison with patent. You can say for patent it's 20 years, your is 50 years, but unlike trademark, it is for a limited duration of time. In the case of trademark, it's for a perpetual time period of time. And this is the law. Designs Act 2000 is the law dealing with designs in India. So with that, we complete 3 items. We are moving on to the 4th item, perhaps the most popular one among intellectual property right. And to have a copyright, you need to show that the creation you have, the creation for which you are claiming a right, the creation for which you are claiming a copyright should fall into any of these categories. You have as many as 6 categories here. I'll just read that out. I can read along. The category of things, creations you have is literary work, meaning to say your right should be either literary work, your creation should be a literary work, artistic work, dramatic work, musical work, sound recording, or cinematography. Unless you can tell the concerned authorities or perhaps to the court also that you can prove, unless you can prove this to the people that your creation falls in these categories, no, it will not have a copyright protection. Moving on, asking the question, what is a literary work? Literary work could be, is this a literary work? I'm sure that you will have an answer in affirmative. Yes, Gitanjali by Rabindranath Tagore is definitely a literary work. And if I ask the same question, is this a literary work in respect of a mathematics and statistics question and statistics textbook, you may have an inhibition to say that it's a literary work, because it may not go well with the understanding of yours and mine. Our understanding of a literary work is that something which has got literary quality. And if you apply that principle here, and mathematics and statistics textbook may not be rich in literary quality. But please note, nevertheless, even though it does not have literary quality in the sense we understand, you and I understand, copyright law has a different take on that. It says anything in print and writing, anything behind which there is an intellectual labor. Just think of what you call think of Gitanjali. There is definitely intellectual labor as some kind of effort and ideas coming from the mind of a person, mind of the author, and to express that. Though expression is of a different nature, there is definitely intellectual labor behind mathematics and statistics question paper, statistics textbook also. If that is so, and if there is invention, there is innovation and investment to bring that out, bring the property out, bring this particular thing out, then you have innovation there, and then you have investment there. If both these conditions are fulfilled, anything in print and writing is an intellectual property in the form of copyright, and it will fall in the category of literary work. So if you are going for listing that out, it could be book, it could be letters, it could be question paper, answer scripts, abridgments, compilations, it could be encyclopedia, dictionaries, and please note the last one, even a software. Even a software, and there's an industry which looks at this, and even a software is considered as a copyrightable item. So software is a copyrightable item and it is an intellectual property. There is intellectual property even for copyright makers. So the next item is artistic work. You have an artistic work, a celebrated one, on the screen. And I'm sure that all of you will identify this particular artistic work and the author there. And then if you go for listing out artistic work, painting, sculpture, drawing, diagram may not, usually it may not be categorized into artistic work, but here it does. Map, chart, plan, engraving, photograph, and whether anything has got whether or not any such work possesses artistic quality. So it is something similar to that of something similar to that literary work. Literary quality as such is not very important. The two things you require are investment and innovation, and if you have these things behind a thing in this category, then you have an artistic work. Then going further with this, dramatic work could be something like a drama. The most important thing is you should have scene by scene arrangement. It could be it could be a drama which is recorded, audio or video recorded. It could be a drama written, or it could be a screenplay. Please note, even a screenplay, tirakatha, cinema tirakatha, even a screenplay of a serial or perhaps even a cinematograph film could be a dramatic work. So moving on with this musical work, in the case of musical work, our usual understanding is that it's a cinema song, an audio song, which is a musical work. But please note that is not the thing you speak about in the context of copyright. In the case of patent, you have a music with which you don't have somebody singing it. Yeshudas is not singing it, nor does Vineet Srinivas. There is no singer involved in it, and there is no lyrics coming in. It's pure music. To put it in this sense, is it's pure sound emanating from the musical instruments. So what you see here is, in the case of copyright, our understanding of musical work is this: it is pure music and nothing else. So moving on with this, I have something which is of recent contextual importance. I'm speaking about the song Darshana from the movie Hridayam. So with regard to this, you have somebody singing it. At least Darshana Rajendran is singing it. That's a female sound. And somebody has written lyrics for that. And Hisham Abdul Wahab is also singing that. And if somebody is rendering it, some people are rendering it. Somebody has written lyrics for that. And there is music to that as well. So it means that it's a kind of composite work. And that composite work is a sound recording. Please note. Moving further with this, you have DDLJ, Dilwale Dulhaniya Le Jayenge, wherein you have a cinematograph film. Cinematograph film is really an RVM as far as copyright is concerned. You've got all the basic materials of copyright, like literary work, artistic work, dramatic work, musical work, and sound recording attached to this or involved in this. It's a composite work. You have stories, screenplay, dialogues, etc., lyrics, music, acting, all this. So all these are coming together, and you have cinematograph film. That's also a separate category of protectable under copyright law. So it's the case with a TV serial, the most popular one. You have as an example on the screen. It also has all these items like videography, stories, screenplay, lyrics, etc., acting, etc. So that's also a cinematograph film for the purpose of copyright law. Please note that. So it could be films as you and I understand. It could be a TV serial. It could be documentaries. It could be TV advertisement. All these are copyrightable items. Going to the next, we have a list of authors under copyright law. In the case of literary and dramatic work, it is author as we understand. You have a picture of a celebrated author on the screen. And then you have musical work, the composer is author there, artistic work, artist is author, photographer is author. These are all commonsensical. And if you go further with this, in the case of film and sound recording, please note it is a producer. Please note it is the producer, not the director, nor the screenplay, playwright or the who is the author. That's a notable thing. And as far as computer generated work, the person who calls the computer to create the work is the author. Going further with this, it is coming to term of copyright in the case of published literary, dramatic, musical, and artistic work. The rule is on the screen. The rule says this: a life of the author for 60 years. That is life of the author for 60 years. That is when did the person die, the author die. From there, you need to have 60 added. So in the case of this particular work, My Experiment with Truth by Gandhi, this is lost, or this had copyright till 2008 because Gandhi died in 1948 plus 60. It is 2008. From 2009 onwards, it is not copyrightable, and that is the reason why. Apart from the original publisher, you have Penguin also publishing this. You have other publication of the same work, and you have eternal publication of the same work. Because of the fact that in 2008, copyright in this particular work has expired, and that makes a difference. From till 2008, it was a kind of monopoly, and after 2008, it goes to the public domain. And if you believe in perfect competition or the competition and the benefits running along with that, you have this. So I think this is the example which will illustrate that. And there is a rule too when it comes to term of copyright. In the case of photograph, cinematograph, film, sound recording, government work, etc., you have a different term for this. That is year of publication plus 6 years. So if you are publishing in 2022, then you may have to add 60 to that. That way that. Meaning to say, in the case of cinematograph film, a new film released in 2022, maybe Bro Daddy or Bhishma Parva, which is released in 2022, will have their copyright. They will have the exclusive right to use this till 2082, 60 years from the date of publication. So that's all with copyright. We have completed 4 items. So then perhaps in another 10 minutes, we'll be able to complete all the other 2. When it comes to integrated circuits, there's electronics that is at stake. And in the case of electronics also, there is a lot of innovation happening. So you have got some examples and pictures and writings on the screen, which will contextualize the matter. Sony is one of the best companies which I can give as give as examples. You have got a lot of innovation happening in the area of electronic items. I may not have to come out with examples to illustrate. I think you will be able to know that better than me, because you're all most of you are of generation newer than mine. Okay, so then you have rights in respect of new arrangements or new innovations in the area of electronics. And the requirements here are new and original layouts are protected. Then registration is compulsory. Duration of protection is just 10 years. It's much less than copyright, but it is 10 years. 10 years is also a considerable period. If a person has a monopoly in the market for 10 years, that is really gives the person a competitive edge. Then you have another major point on the screen. The law that deals with semiconductor chip protection in India is the Semiconductor Integrated Circuits Layout Design Act 2000. So that's all about integrated circuits. So other things are similar to that of other intellectual property rights. So it is 2000 law which deals with integrated circuits. So we complete five items here. We're moving to the 6th. I've got some pictures over the screen. I think especially people from biotechnology department will have some interest in this. Grigor Medel's picture, the father of genetics. So here, what you're on is intellectual property in respect of plant varieties, new varieties of plant. If you have a new variety of a plant, and that plant has a feature which is not there for an ordinarily existing, a naturally existing variety, then you have a chance for intellectual property protection in respect of plant varieties. That should have a better performance than the naturally existing thing, and it should have a better feature, plant feature, when compared to the naturally existing thing. Your dwarf coconut tree, Kolenchery, could be a good example for that. It really solves the problem of plucking coconut tree, which is one of the major problems in Kerala these days. So instead of going up, you bring that coconut tree down, and it gets better performance. It gives an yield in 3rd year, or on completion of 3 years, which is not the case with natural variety. So it has certain features, and its performance is different or better than the natural existing one. So you have 2 category of people who get protection under this law. That is breeders' right, who are doing these things or making changes and manipulations in the formal setting. They are called breeders, and other people are ordinary farmers, the traditional variety. So both these people get protection under this law. So there are certain features you may have to note. The plant variety for which you claim an intellectual property should be novel, goes without saying. It should have a distinctive feature, as I said already, and it should have uniform. If you have 1 acre where you have Kolenchery planted, in whole 1 acre, it should have by and large the same features and performance, and it should be stable even for the next generation of nil rice. You should have the same feature. It should give you in 3 months or 6 months, whatever it is. So going further with this, duration of protection is for 15 to 18 years, and the law that deals with this particular intellectual property is the Protection of Plant Varieties and Farmers' Right Act 2001. I think we can move on fast and complete the formalities. Geographical indications. I've got some pictures over the screen, which will definitely will be able to will help you understand the matter. The first one is Aramula mirror, second one is green and Darjeeling tea, third one is Mysore sandal soap, and the fourth one is Scotch whiskey. And if you go for if you ask the question, what is common in all this? The common things are Aramula, Darjeeling, Mysore, and Scotland. And it's very clear that all these are name places or geographical names. So what are you on is geographical names having commercial value. You have other examples like Palakkad and Mata. You have Alappi Kayar, Alapura Kayar. You have Payanur Pavitram. You have Wayanad and Manjal. You have very many examples from Kerala itself. So these are all examples for this, and you sell definitely better. You sell Darjeeling tea better and for a better price than what you call an ordinary tea. So Scotch whiskey is much better. It has got a better market than the ordinary whiskey. That's what people say, and that's what I'm given to understand. So notable things here are it's a group right and it's a permanent right. Please note, both these are important ones. It's a permanent right. There is no, unlike many of the other intellectual property rights, there is no time limit for that. It's permanent. It's until the last day if there is a D-Day, and it's a group right. That's also a notable feature because there are very many people who make Aramula mirror. That's the same case with Darjeeling tea. There are very many people who make true Darjeeling tea. All these people are entitled to use this. Also, it's a kind of group right. So its office is in Chennai. Otherwise, it is in other places like Chennai, Mumbai, Calcutta, and Delhi. When it comes to other intellectual property rights, and GI office is in Chennai. So jumping to the last, that is trade secret. If you have the list, have a look at that. This is the 8th item. So here we speak about it could take different forms. It could be in the form of copyright. It could be in the form of patent. It could be in the form of trademark. It could be in the form of anything else, any of the other intellectual property which has gone by, which we discussed already. So here it may be of any form, but here it has got a different feature. The feature here is information which has a commercial value. That's the thing I have already said. Then it is secret. It's kept secret. So as it is secret, something which is known to me is not known to you. So I've got an edge, competitive edge. And if it's in the commercial field, it's commercial edge. And that matters. And the best example I can have in the world, perhaps, is this. Coca-Cola formula is kept in a bank vault, and this is not known to anyone, apart from 2 people who know that. And this is so from 1886, 1886 when Coca-Cola formula was formulated for the first time. So it's almost 1.5 century. And for 1.5 century, this formula is kept secret. And this formula is kept secret. The company which is in competition with this is not able to offer the same taste and same feeling if it really conveys any feeling to you, feeling as Coca-Cola does. So it gives a competitive edge to Coca-Cola. So is the case with very many other companies. You've got so many examples for this. So as I said, it could be a formula. It need not be a formula alone. It could be algorithm, which is there in a computer. It could be technical know-how. It could be data compilation. It could be business strategy. It could be financial information, personal records even. A customer list, which is not available to the second company, will be definitely useful to the first company. And it could be information regarding research and development. So this is all about intellectual property rights. Let's have the understanding that this is a permanent right. Till the day you can keep this as a secret, you will have the right. But once it's out, it goes out to the public domain. You lose your right. And please note, there is no law in India as far as this particular area of intellectual property is concerned. We manage this with the system of contracts. Something like NDA. A person who joins for a job will be made to sign. You should made to sign something like an NDA, non-disclosure agreement. They're all part of trade secret protection. We don't have a law in India as such. We don't have a decision from Supreme Court. We don't have a law from Parliament. So there is a, you can almost say there's a legal vacuum, but we manage it with copyright and the contracts. So that's all about intellectual property rights. Thank you for listening. Let's have the list again. The first item of intellectual property is patent. There you are speaking about inventions. There you have science and technology. Second one is trademark. You speak about things like SBI and brands like this. In the case of industrial designs, it is a design of a shape and configuration, color, etc., which is at stake. And copyright has got 6 subject matters: literary and artistic works, copyright, etc. Then you have semiconductor chip, where you have electronic items coming in. You have plant varieties, your coolant thing, or technology in biology. That's an example there. Then you have geographical indications. The examples like Palakkad and Matai and Scotch whiskey could be examples for it. And you have trade secrets also, where the best example is Coca-Cola. That's all from my side. Thank you for listening, and thank you for the invitation. Thank you so much. And in case you have any doubt or anything to communicate, you have my email address on screen. That is lowwellman@lloyd.com. Thank you so much. Thank you. Who will take it?
If anyone has any doubts or queries, you can ask now. If there are no questions, Rincy